Okay, we'll call the hearing of the Senate Judiciary Committee Subcommittee on the Constitution to order. Today's topic is Protecting American Citizenship 3, Denaturalization and its Constitutional Limits. This hearing will examine the legal and policy issues surrounding denaturalization and why it is a critical safeguard of the value and meaning of American citizenship, as well as the security and harmony of American society. We'll make our opening statements, the ranking member and myself, then we'll introduce our witnesses, swear them in, and then hear their testimony before proceeding to 5-minute rounds of questioning. American citizenship is sacred. It's the highest civic honor this country can give. It carries rights, duties, allegiance, memory, inheritance, and obligation. It means joining the American people and accepting responsibility for the future of the nation. But for far too long, Washington treated naturalization like paperwork. Check the boxes, say the words, get the passport, collect the welfare check and federal tax credit, and move on. The approach desecrates American citizenship. It insults every immigrant who came here honestly, followed the law, learned our history, embraced our Constitution, and took the oath in good faith. The Constitution gives Congress the power to establish a uniform rule of naturalization. Congress used that power to require more than residency and forms. Instead, applicants must show good moral character. They must be attached to the principles of the Constitution. They must be well disposed to the good order and happiness of the United States. When someone lies during that process, conceals material facts, hides criminal conduct, masks allegiance to a foreign enemy, or swears loyalty with mental reservation, he commits fraud against the United States and the American people. Fraud has desecrated American citizenship, but that desecration did not happen overnight. It built up over the decades of lax enforcement, cheapened standards, and political cowardice. Reconsecrating citizenship requires a remedy strong enough to remove those who abuse it. That's called denaturalization. Denaturalization cancels citizenship that should never have been granted. It enforces the conditions Congress placed on naturalization. It protects the American people from those who abused our generosity and turned the oath into a scam. The Supreme Court has made the rule clear. No alien has the slightest right to naturalization unless every statutory requirement is met. Citizenship obtained by fraud is stolen status. Stolen status should be revoked. Right now, across the country, we're seeing the consequences of a broken naturalization system that loosely granted citizenship and then refused to revoke it from those who stole it. A DOJ and DHS review found that naturalized citizens made up more than 25% of the international terrorism-related convictions from September 11, 2001 to 2016. Since then, the pattern has continued. Terrorism-related crimes, concealed sex offenses, healthcare fraud, drug trafficking, espionage, and massive fraud against government programs. In Minnesota, many of those involved in the Feeding Our Future scandal that stole $250 million from a federally funded children's nutrition program were naturalized citizens. Money meant to feed needy children was spent on luxury goods, vacations, real estate, and sent overseas. It was stolen. That crime attacked more than the public trust. It attacked the public trust and the sacred trust between the nation's citizens and their government. When someone naturalizes and then joins ISIS, supports Al-Qaeda, affiliates with other terrorist organizations, spies for a foreign intelligence service, joins a cartel, or steals millions from American taxpayers, all recent examples of crimes committed by newly naturalized citizens, prosecutors should ask the obvious question: why did this person conceal when he was asked to become an American in the first place? And what did they conceal? If a man takes the oath of allegiance and then joins ISIS, the fraud likely began long before the battlefield. If a man swears attachment to the Constitution and then spies for a foreign country, the betrayal likely began before the indictment. If a man claims good moral character and then steals millions from the American people, the lie may have been present at naturalization. The Trump administration is right to revive denaturalization. The Department of Justice must bring these cases. USCIS should continue referring them for prosecution. Prosecutors should pursue terrorists, fraudsters, spies, sex offenders, violent criminals, and anyone who concealed material facts to obtain citizenship. We need a serious nationwide denaturalization effort against fraudsters, felons, terrorists, spies, and anyone who obtained American citizenship by deceit. If the government never revokes citizenship obtained by fraud, the oath becomes theater. The application becomes a game. The American citizen becomes the sucker in his own country. That is why I've introduced the Stop Citizenship Abuse and Misrepresentation Act, the SCAM Act. The name fits because the abuse is real. If you scam the United States to get citizenship, you should lose it. And we have every right to revoke it. The SCAM Act gives the government stronger tools when serious conduct shortly after naturalization reveals the truth that was hiding during the process. Major fraud against government programs, affiliation with foreign terrorist organizations, aggravated felonies, and espionage. Those acts should serve as powerful evidence that the person lacked good moral character, lacked attachment to the Constitution, or lacked a disposition towards the good order and happiness of the United States when he became a citizen. The SCAM Act also fixes a legal absurdity. Under current law, even after someone is denaturalized, courts can prevent their deportation by treating crimes committed during the fraudulent citizenship as if they do not count for deportation. This makes no sense. When citizenship is revoked because it was unlawfully obtained, the law should permit deportation. Prison alone cannot protect the American people if the terrorist, spy, or fraudster remains here after release. A recent case demonstrates the need to expand our denaturalization laws and ensure deportation. In 2016, a naturalized citizen was convicted on terrorism charges for trying to carry out a terrorist attack for ISIS. He was sent to prison, but was released early in 2024. He wasn't denaturalized, and he wasn't deported. So after his release earlier this year, he committed a terrorist attack at an American university, attacking a ROTC classroom and killing a lieutenant colonel. The terrorist should not have been allowed to remain a citizen in the United States. He should have been denaturalized and deported. And if he had been denaturalized and deported, that horrific attack would have been prevented. Fraudsters should be afraid. Terrorists should be afraid. Spies should be afraid. Cartel members should be afraid. Anyone who lied themselves into this country and obtained citizenship should be afraid. The American people are tired of a government that treats their citizenship as cheap, their laws as optional, and their generosity as an invitation to be exploited. This subcommittee will defend the value of American citizenship. We will support the Trump administration's denaturalization efforts. We will fight fraud in all forms. We will fight to pass the SCAM Act. Denaturalization is citizenship safeguard whose time has come. I turn it over to the ranking member.
Thank you very much, Mr. Chairman, and I want to thank our witnesses for being here. Today is our third hearing, this Congress and this subcommittee, on, quote, protecting American citizenship. All of them have focused on the topic of immigration, and today's topic is on denaturalization of non-native-born citizens, and I will get to that in a moment. But first, I want to make a point at what we've not looked at. The administration has, it is absolutely clear, a very radical goal, and that is mass deportation of immigrants from our country. This includes dreamers, DACA recipients, folks here illegally, and I oppose that. It's doing real damage to our country. And as part of that effort, we've seen the abusive lengths that this administration is willing to go. The violence in Minnesota, that's receded. But the cruelty of these policies to create fear and anxiety include targeting legal immigrants. The Trump administration has violently clamped down on Americans exercising their constitutional rights. In Minnesota, of course, we saw the killing of two people, a 37-year-old nurse, a 37-year-old mother. Immigration agents have detained U.S. citizens, including a Vermonter, a respected principal, Wilmer Chavarria, a school superintendent who was pulled out of a Houston airport and told, quote, "You have no rights here." The Department of Homeland Security has authorized immigration agents to enter the homes of Americans without a judicial warrant. Immigrants have been deported without due process, sometimes in defiance of federal court orders prohibiting their deportation. The White House has turned to pulling every bureaucratic lever that the White House has within its considerable power, cutting off immigrants from jobs, financial services, medical care, tax credits, and daycare. There was a woman, an immigrant from El Salvador, legally in this country, providing janitorial services at the Boston airport, a job she revered, gave her life dignity. She did it well. And last year, the administration had her fired, declaring that because of her legal immigration status, she could not carry out the work she had done for almost 3 decades. And this is all part of a radical crusade against immigration. It's not about securing the border. We're for that. It's not about deporting criminals. We're for that. It's about going after people, including folks who are here illegally. And I absolutely oppose that. Mr. Chairman, yesterday, my granddaughter graduated from Montgomery Blair High School. And I attended. There were 2,000 kids in her class. And many of the speakers were first-generation graduates of high school. And the pride of the parents seeing their kids graduate, in the words of these kids, where they spoke about values, they spoke about a life of purpose, they spoke about commitment to community, they spoke about friendship. We should be honoring and protecting those kids who are our future and putting our energies into protecting them and not just focusing on these other issues that are about implementation of this mass deportation policy. This is too important for the future of our country, and it's very important to the present of our country that we treat legally entitled people with real dignity. Turning to the topic of today's hearing, denaturalization, I want to be clear. I agree with you that we shouldn't allow people to abuse our immigration system. People should not be able to deceive the government and acquire citizenship by lying. We should be tough on fraud, but expanding denaturalizations is not in furtherance of that goal in this administration. It's intended to create fear in our communities, to prevent people who are legally here from showing up to school, working, or seeing doctors. And by the way, some of those kids had family members, I'm talking at Montgomery Blair, who were picked up, even though they were here legally. Under current law, naturalized citizenship can be revoked if it was procured illegally or by concealment or of material fact or willful misrepresentation. So again, I want to be clear. I support that. But I don't agree that naturalized citizens should be punished for something that happens after they become a citizen. And that is just not my view. It's the view of the Supreme Court. So we do not have to reach too far back in our nation's history to see that a familiar cycle is unfolding. Denaturalization efforts have been clustered around both world wars and the Red Scare, and under the guise of national security has been abused, as some folks abuse the immigration system in targeting people, including immigrants, for their associations, for their speech, and political beliefs. It's been abused in our history time and again. And yes, American citizenship, Mr. Chairman, is precious. It is precious. And those kids that I saw at high school, they believe that. They are committed to making this a better country, to making ours a better community. But broadening the administration's authority to strip citizenship would put 24.5 million naturalized Americans at risk. And in April, I attended a naturalization ceremony back in Vermont, and I think a lot of my colleagues have done that in their states, and it's one of the most ennobling and inspiring experiences that we can have, to see a person who, by choice, has undertaken the duties and responsibilities of citizenship. They see it as a responsibility, and they put in years of hard work in order to achieve that status. So yes, where there's fraud, where there's lying, and that is the basis upon which a person received a citizenship certificate, take it away. but not use this process to add to the attack on people, so many of whom are here who are here legally and who have the aspirations of those young kids, graduates of high school that I met yesterday. I yield back.
Senator Durbin.
Thank you, Mr. Chairman. It was my honor to chair this subcommittee. For a number of years, I tried to focus on issues related to the Constitution and fundamental civil and human rights. It is absolutely beyond me why, with all the challenges facing America, we are talking about denaturalization of citizens. Since the president took office last year, he and his supporters have used every available tool at their disposal to target their political opponents. Last week, the Department of Homeland Security Secretary Mullen even threatened, despite the objections of the Transportation Secretary, to punish the so-called sanctuary jurisdictions by targeting their airports. And the president and his supporters have repeatedly used threats of denaturalization to chill political speech and intimidate naturalized Americans who dare to challenge Trump's policies. In my office in the Capitol, on the credenza behind my desk, is a graying document that is a naturalization certificate of my mother. She came to the United States at the age of 2, brought here as an immigrant from Lithuania. After she was married and had 2 children, she decided to become a citizen of the United States. I have her naturalization certificate, which she handed to me before she passed away. I'm proud of that. I'm proud of the fact that it also declares that I'm a proud son of an immigrant. She's no longer with us, and therefore could not be threatened by anything that we say today at this hearing. But the thought of taking something so precious away from her because of her political views doesn't sound like the America that she was aspiring to be part of. In a Thanksgiving Truth Social post, the president even said, "Denaturalize migrants who undermine domestic tranquility." If you're a student of the Constitution, look at that as a standard for removing the citizenship of one of your neighbors. This spring, MAGA Congressman Chip Roy introduced the, quote, Mamdani Act of 2026, which aims to denaturalize individuals who advocate for socialism. Wonder what he defines as socialism. Medicare? Sound familiar? It should. These efforts harken back to Joe McCarthy, the tail gunner from Wisconsin, when naturalization was used as a tool to silence political dissidents. For the young people who are in the audience, I hope you've studied that era, but if you haven't, in the 1950s, a Republican senator from the state of Wisconsin decided to start looking for those people who just might be communist in the United States government. Well, he had hearing after hearing, and at the end of the day, there were disastrous results that hurt a lot of innocent people. There was talk of denaturalizing those people who turned out to be communists or even were sympathetic to them. Among them was Harry Bridges. Harry Bridges was a renowned Australian-born labor leader accused of being a communist. During that McCarthy era, he faced a relentless campaign to revoke his citizenship, but the Supreme Court ruled in Bridges' favor, not once, but twice. In fact, the court has repeatedly held that stripping citizenship based on an individual's views or expressions, quote, would run counter to our traditions, unquote. The court placed a high burden on denaturalization to prevent the types of abuses we saw during the McCarthy era. Relying on the 14th Amendment, the Supreme Court found that Congress does not have the power to take away any American citizenship unless that citizenship was unlawfully procured. It is also held that all Americans are on equal footing in the eyes of the law, with the exception of eligibility for the presidency. Naturalized citizens are no different than those who were born here. With those high barriers under the law, the federal government now rarely engages in denaturalization. And when it does pursue it, it goes after war criminals and individuals who committed serious naturalization fraud. Even under the first Trump administration, only estimated 160 people in 4 years were denaturalized. So why hold a hearing to discuss this rare process? The title of this hearing says it all, quote, protecting American citizenship. Should American citizenship be, as the president and his MAGA faithful have suggested, about fealty to one man and his ideology? Or should it be about an individual's fealty to their country and our Constitution? I happen to believe the latter. Just look at DACA recipients and dreamers. They grew up pledging allegiance to the flag and serving our country each day as doctors, teachers, and firefighters. They're Americans in every way but their paperwork, and they deserve a path to citizenship in my estimation. But this administration is doing everything possible to stop hardworking immigrants, even those who follow every rule, from securing citizenship. Last week, the administration issued a new policy of force that would force most applicants to go abroad to get a green card. After outcry from around the country, DHS claimed to roll back this policy, saying that applicants who, quote, benefit the national interest and provide economic benefits would not be affected. The administration has not clarified what this means, but we can take an educated guess. Look at the refugee program. The president has barred all refugees from coming to the United States, except those whose admission it deems in the national interest. The only refugees the Trump administration has decided are qualified so far, white Afrikaners. These policy changes, the targeting of DACA holders, new barriers to the green card, and an end to the refugee program are devastating to immigrants and American communities. They deserve our attention. Denaturalization, just what decade are we talking about?
Okay, at this point, I will introduce the majority witnesses, and then Senator Welch will introduce the minority witness. Ken Cuccinelli is here. He's a senior fellow for the Center for Renewing America. Mr. Cuccinelli has been a trial and appellate litigator, including constitutional law, for over 30 years. He has served in many key roles, including as Virginia's Attorney General and the acting director of USCIS and the acting deputy secretary for the Department of Homeland Security. Mr. Cuccinelli now serves as the senior fellow for immigration and homeland security at the Center for Renewing America, in which position he conducts research and writes on matters related to his experience addressing immigration and protecting our homeland. Mr. George Fishman is a senior legal fellow at the Center for Immigration Studies, where his scholarship focuses on these issues. Previously, he had served as a deputy general counsel at the Department of Homeland Security, acting chief counsel at USCIS, as a policy advisor to the president in the Office of American Innovation, and as special counsel to the House Homeland Security Committee. Mr. Fishman also spent 2 decades as chief counsel for the U.S. House Judiciary Committee's subcommittee with jurisdiction over immigration. He's one of the nation's top denaturalization scholars.
Thank you. And we have Professor Peter Spiro, who's the Charles Wiener Professor of Law at Temple University Beasley School of Law, who specializes in citizenship law and theory. The author of 3 books. I won't go through them, but they'll be available.
Anywhere books are sold.
Anywhere books are sold, but thank you. And it serves on the Council on Foreign Relations. He served on the Open Society Institute and the European University Institute. Previously served as professor of law at the University of Georgia. And this is of special note to me, clerk for Justice Souter from New Hampshire. An outstanding member of the judiciary, and he served as director of democracy and the staff of the National Security Council, as an attorney advisor in the U.S. Department of State's Office of the Legal Advisor, and as a resident associate at the Carnegie Endowment for International Peace. Professor Spiro holds a BA from Harvard College and a JD from the University of Virginia Law School. Thank you so much for being here.
Okay, it's the tradition of this committee to swear in all the witnesses who testify before it, so would you please stand and raise your right hand? Do you swear that the testimony you're about to give to this committee is the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I'll be right back.
Okay, now that the witnesses have been sworn in, they'll give their opening statements, and we'll begin with Mr. Cuccinelli.
Thank you, Mr. Chairman. American citizenship is the most valuable immigration benefit that this nation confers, what the Supreme Court has called a priceless treasure. No foreigner may claim any right to it. And precisely because it is so consequential, Congress requires that those who seek citizenship through naturalization demonstrate that they deserve it, that they are persons of good moral character, attached to the principles of the Constitution, and well disposed to the good order and happiness of the United States. That's the law of the United States. I had the honor as acting director of USCIS of administering the oath of allegiance to hundreds of new citizens. It was a moving experience every time, for me and for them. That oath is a solemn covenant. I'm here today because I'm deeply concerned our system is no longer holding applicants to the proof that oath demands. History bears out that concern. The Clinton administration's Citizenship USA program made production the guiding principle at the expense of accuracy. More than 180,000 applications were processed without proper FBI fingerprint checks, including 80,000 that generated criminal records never reviewed before citizenship was conferred, 80,000. The weaknesses CUSA exposed, inconsistent standards, inadequate vetting, check-the-box adjudication, have persisted in various forms ever since. When the front end fails, denaturalization becomes essential. Operation Janus identified roughly 315,000 cases with missing fingerprint data, including at least 858 individuals who had deportation orders, adopted false identities, and naturalized without disclosing any of it. Operation Second Look proposed reviewing 700,000 alien files for fraud, yet only a fraction of the cases identified were ever thoroughly followed up. 2 cases show what is at stake when the system fails and the tools to correct it are inadequate. On March 12th of this year, Mohammed Bailar Jallah, a naturalized citizen from Sierra Leone and convicted ISIS supporter, walked into a ROTC classroom in Old Dominion University in my home state of Virginia and opened fire, killing Lieutenant Colonel Brandon Shaw, a decorated combat veteran of Iraq and Afghanistan, and wounding 2 cadets. Despite his terrorism conviction, Jallah was never denaturalized and deported. Under current law, terrorism is prima facie evidence of fraudulent procurement only within 5 years of naturalization. Because Jallah's conduct fell outside that window, the government had no clear path to remove him. A brave American soldier died because of that gap. The case of Mirsad Ramik may be even more disturbing, because this man never should have been naturalized at all. As the Sixth Circuit recently recounted, at his naturalization ceremony, Ramik refused to recite the oath of allegiance. Instead, he proclaimed an Islamic oath and cursed all non-believers. Let that sink in. He stood in an American courtroom, refused the oath the law requires, cursed those he called non-believers, and was naturalized anyway. What followed was tragically predictable. Ramik traveled to Syria, joined ISIS, fought in the siege of Kobani, a campaign that killed thousands and displaced hundreds of thousands, celebrated the beheading of Coptic Christians, and expressed hope that President Obama's daughters would be sold as slaves. The Sixth Circuit just vacated his 8.5-year sentence as shockingly low, warning that courts' refusal to incapacitate terrorists has deadly consequences, and cited the Old Dominion shooting that I just recited as proof. We must act on multiple fronts. Strengthen the front end so adjudicators conduct meaningful inquiries and every applicant is thoroughly tested for hostility to American principles. Resource denaturalization so the work of Janus and Second Look continues, and close the legal gaps. The 5-year window for terrorism as prima facie evidence of fraud is far too narrow, and frankly, I don't know why there would be any time limit on something as anti-American as terrorism. The Constitution entrusts Congress with plenary authority over naturalization. This is a problem you can solve, and I urge you to do so. American citizenship must mean something. When we cheapen it by conferring it on those who are hostile to everything it represents, we fail every immigrant who took the oath in good faith, every native-born citizen, and the nation itself. I look forward to hearing from the other witnesses and working with you to address this problem. I would note you do have the person that I would call the nation's premier expert on the subject working for the U.S. government, and that is Joe Edlow, who is currently the head of USCIS. He has been both an immigration lawyer, he has represented people in front of the government, he has been an ICE prosecutor, and he has worked on denaturalization. He's literally worked on every aspect of this issue, and he is a resource that you can readily call upon. Thank you.
Thank you, Mr. Cuccinelli. Professor Spiro, we'll hear from you next.
Thank you, Senator Lee, and distinguished members of the committee, and thank you for your invitation to testify before the subcommittee today about constitutional constraints on denaturalization. Any consideration of denaturalization must start with the elevated place that naturalization has held in our constitutional culture since the nation's founding. As Justice Marshall remarked in the Supreme Court's 1824 decision in Osborne versus Bank of the United States, the naturalized citizen, quote, becomes a member of the society, possessing all the rights of a native citizen and standing in the view of the Constitution on the footing of a native. Naturalized citizens are co-equals in our constitutional order. They enjoy the same security of citizenship as is enjoyed by native-born citizens. That security is nearly complete. As Justice Black wrote in Afrorim versus Rusk, quote, the 14th Amendment was designed to and does protect every citizen of this nation against a congressional forcible destruction of his citizenship, end quote. It is effectively impossible for Americans to lose their citizenship against their will. There's one respect in which naturalized citizens stand on different footing than those born with citizenship. Because naturalization involves a volitional act on the part of the applicant, and because naturalization is appropriately subject to eligibility requirements, there is the possibility of unlawful procurement. Where naturalization is unlawfully procured, it can be rescinded. But that remedy is highly constrained. The government shoulders a heavy burden in making a case for denaturalization. In line with repeated pronouncements of the Supreme Court and reflecting the sanctity of citizenship however acquired, denaturalization can only be undertaken where supported by, quote, clear, unequivocal, and convincing evidence which does not leave the issue in doubt. Naturalization, once conferred, should not be taken away without the clearest sort of justification and proof, end quote. Denaturalization can only be triggered by circumstances incident to the naturalization application itself. There is no projecting forward of naturalization requirements where an individual possessed the statutory qualifications for naturalization at the time of naturalization. Proposals to expand denaturalization grounds concede this baseline. For example, S 3674, the so-called Scam Act, aims to take post-naturalization conduct and relate it back to the naturalization application through the requirements of good moral character and constitutional attachment. But to take post-naturalization criminal activity to reflect an applicant's qualities some years earlier presents an evidentiary exercise that hardly seems intelligible. Determinations of illegal procurement consider how the real facts would have affected a reasonable government official properly applying naturalization law at the time of the naturalization application. Proposals to expand denaturalization would require the following type of inquiry. How would the government have determined good moral character or some other qualification if it had known that an applicant was going to engage in certain conduct at some point in the future? That, senators, is crystal ball justice. This is particularly true where the government's case rests on issues of fraud or belief, spheres in which, as Justice Frankfurter counseled in the Baumgartner case, quote, proof is treacherous, and objective judgment, even by the most disciplined minds, is precarious. At the very least, the proposals would open the door to arbitrary and inappropriately subjective speculations about a citizen's prior state of mind. Suggestion that post-naturalization associative activity should call into question qualifications for naturalization at the time of its granting would also pose serious concerns under the First Amendment. Make no mistake, if enacted into law, bills such as S 3674 would at the least be highly circumscribed by the courts. The Supreme Court may be friendly to the powers of the political branches in the context of immigration, but it takes an altogether more searching posture with respect to citizenship. In the meantime, legislative proposals relating to denaturalization, coupled with the Trump administration's aggressive deployment of existing authorities, sends a message to all naturalized citizens, some 25 million of them, that their citizenship is less secure than those of fellow Americans born with the status. Even if few actually suffer denaturalization, the message to all naturalized citizens is that their citizenship is second-class citizenship. Those seeking to police naturalization more aggressively may be seeking to better protect the institution of citizenship, but these efforts are more likely to diminish citizenship than they are to safeguard it. Thank you again for the invitation to testify today. I look forward to your questions.
Thanks, Professor Spiro. Mr. Fishman, you're next.
Thank you. I am honored to have the opportunity to testify before you and the other members of the subcommittee today regarding the constitutional parameters of denaturalization. Over the past few months, 3 naturalized citizens have murdered or attempted to murder Americans in apparent terrorist attacks. It strains credibility to assert that when naturalized, they had met the requirement of being of good moral character, attached to the principles of the Constitution, and well disposed to the good order and happiness of the United States, or that they truthfully professed when taking the oath to support and defend the Constitution and renounce all allegiance and fidelity to nations of which they were once subjects. Why does it matter that they were naturalized? Naturalized citizens are not subject to deportation. They can serve in Congress, can vote in federal elections, and have an unfettered ability to work for the federal government. The Supreme Court has stated that citizenship obtained through naturalization is not second-class citizenship, but carries with it the privilege of full participation in the affairs of our society. Federal law provides that the government can seek to denaturalize those who illegally procure denaturalization or procured it by concealment of a material fact or by willful misrepresentation. The court has made clear that an applicant for naturalization must be in strict compliance with all the congressionally imposed prerequisites to the acquisition of citizenship, and failure to comply with any of these renders citizenship illegally procured. However, the court has also ruled that, at least under current law, the government must provide clear, unequivocal, and convincing evidence in a denaturalization proceeding. But the court has seemingly indicated that Congress could substitute a lower standard of proof. Can the government revoke naturalization based on behavior engaged in or beliefs expressed post-naturalization? As one federal court put it, post-naturalization evidence can at best rise only to the level of evidential facts, as to a citizen's state of mind at naturalization. While the Supreme Court has expressed dubiousness as to whether disqualifying views expressed after naturalization are accurate representations of a citizen's views when he took the oath, the court has not held that they are insufficient proof as a matter of law. In 1950, a special subcommittee of this committee explained that during World War II, the Supreme Court began to hold the government to such a strict standard of proof that it became very difficult to denaturalize citizens with Nazi sympathies. The subcommittee thus recommended enactment of a new federal law, providing that joining a subversive organization within 5 years after naturalization shall be presumptive but rebuttable evidence that naturalization was obtained unlawfully. But it emphasized that this is not intended to place a condition subsequent upon naturalization, but rather simply to create a rule of evidence. The recommendation was enacted into law in the Internal Security Act of 1950, and in modified form remains the law today. One difficulty in assessing the presumption's constitutionality is that it has rarely been invoked and as far as I can tell, never been the subject of a federal court decision. But we can look for guidance at federal court decisions regarding other such presumptions. In 1913, the Supreme Court concluded that for a legislative presumption of one fact from evidence of another not to constitute a denial of due process of law or a denial of the equal protection of law, it is only essential that there shall be some rational connection between the fact proved and the ultimate fact presumed. The court concluded that the denaturalization presumption it was reviewing passed this test. It stated that Congress has indicated its opinion that the intervening period may be as much as 5 years without rendering the presumption baseless. It noted that that period seems long, but that we are not prepared to pronounce it certainly excessive or unreasonable. But the court cautioned that as the intervening time approaches 5 years, the presumption necessarily must weaken to such a degree as to require but slight countervailing evidence to overcome it. Conversely, when the intervening time is so short as it is shown to have been in the present case, the presumption cannot be regarded as yielding to anything short of a substantial and convincing explanation. Thank you.
Thanks so much for your opening statements. We'll now turn to 5-minute rounds of questions. We'll be asking those in order of seniority, subject to the early bird rule, and we'll begin that now. First of all, I want to thank the committee chairman, Senator Eric Schmidt, for giving us this chance to explore these important issues today at this hearing. I'm proud to co-sponsor the SCAM Act because I believe citizenship must be grounded in conduct that confirms rather than contradicts the promises made in connection with the naturalization process. This is meaningful, and citizenship, when it's granted through the naturalization process, can't be secured through fraud. Now, Mr. Fishman, I'd like to start with you, if possible. When an applicant takes an oath of citizenship, what obligations does that person undertake, just briefly?
Right here, it's essentially the good order and happiness of the United States.
Duty, allegiance, fidelity to the Constitution. Yeah.
To the Constitution, to absolutely renounce all allegiance to any government or critical potentate of a country that they were a subject of in the past. And the courts have made clear that when a naturalized citizen or an alien takes the oath to become a naturalized citizen, there's no opportunity at that time for that person to be cross-examined to determine whether they're truthfully stating that oath. It's not like there was court litigation in the past.
Right.
That's something that can be considered later on. Were they truthfully professing the words they were uttering?
Right, and it's neither arbitrary nor capricious for Congress to take this very seriously, because it's a serious matter to become a citizen of a nation. It's why you don't want people having access to the citizenship through fraud. And if citizenship was obtained through fraud, that's a problem, and it's a problem that we ought to try to remedy. Is that correct?
Yes.
Now, how would the Founding Fathers have viewed an applicant who may have deliberately, fraudulently concealed affiliations, loyalties, conduct, perhaps beliefs that are fundamentally at odds with the citizenship requirements?
My guess would be they would be aghast and would consider that appropriate to denaturalization.
Right, and they made this clear that we don't really have to guess that much either. In the Naturalization Act of 1790, for example, Congress required proof of good moral character and an oath to support the Constitution, and then in 1795, Congress amended that to add requirements that applicants must be attached to the principles of the Constitution and well disposed to the good character and happiness of the United States. Now, Mr. Cuccinelli, there is, I think, an important distinction between constitutionally protected associations and affirmative misconduct, including fraud, violence, insurrectionary activity, or terrorism. Now, if the government could properly deny naturalization to someone who applied to become a naturalized citizen, because of participation, for example, in a terrorist enterprise, why should it not be able to denaturalize that same person when the affiliation was deliberately, fraudulently concealed during the application process?
Well, they most certainly can. I think that Professor Spiro painted accurately the tall hill the government has to climb in a case-by-case basis.
Sure, it shouldn't be done for light or transient reasons, to be sure.
Correct, and you're not describing light or transient reasons. And that is available for various durations of time, not court-tested in terms of the length of that time. And of course, the Scam Act would double the current period from 5 to 10 years. As yet, we don't know how courts would respond to that, except that on the concept, the courts have accepted that relevant behavior after naturalization that has a nexus with the obligations for naturalization, while it's rebuttable, is still an allowable form of evidence that can be used for denaturalization.
Right. Now, given that certain transnational drug cartels have been deemed terrorist organizations, not just willy-nilly, but because they're engaging in actual acts of terrorism.
Right.
Not all of them, but some of them. Should cartel-related conduct, affiliation with a cartel, working on behalf of a cartel, with a cartel, such a cartel as has been designated as a terrorist organization, should that enter into the discussion when considering denaturalization?
Well, most assuredly should. I mean, they are essentially quasi-state actors at war with the United States, or at least victimizing the United States. And they are, unlike, say, an Islamic terrorist organization that is motivated by religious precepts, organized, the cartels are massive, literally to the level of government level.
Sometimes rivaling their host state's
Well,
government.
they control territory in Mexico. They are the government of a sixth of Mexico by territory.
Some would put the number higher than that, but yes.
Some would. Well, another sixth is contested, as you note, with the federal government of Mexico, and they are they use those resources and they wage war on the United States. So people assisting them, and it's not a formal state of war, and they're not a formal government. Nonetheless, those assisting them should be in the same boat as someone assisting ISIS. They both attempting to victimize America and Americans. They're doing it quite intentionally, and that should be more than enough.
Particularly with regard to those organizations that are, in fact, assisting ISIS. Is that right?
Well, that's certainly true.
Yep. Thank you, Mr. Chairman.
Yeah, if I could.
Yep.
So one difference, I lump them together, say an ISIS and a cartel. But one difference is that the cartel simply wishes to gratify its own desires, whereas, say, an ISIS seeks to end the United States of America. And that is a material difference between the goals of the two entities. So there is a meaningful difference between someone helping ISIS and someone helping, say, CJNG out of Mexico. Nonetheless, the personal impact in the United States may be the same, but the broader strategic goals of those individuals are very different.
Meaning, given the proximity of the harm from CJNG to the United States, if ISIS is operating primarily half a world away, CJNG is operating right across the border, and if CJNG is materially assisting ISIS or other international terrorist organizations, it can be difficult to differentiate that from ISIS or other terrorist organizations.
Well, in those instances, absolutely.
Senator Rono.
I thought it was going to be Senator Welch, but
He yielded to you because he's such a statesman.
would you like to go?
No.
Okay.
I want to learn.
Well, thank you very
from
much. I think this is a fairly bizarre hearing, to tell you the truth. So President Trump spent all of 2024 insisting that he was going to go after immigrants who commit serious crimes, the so-called worst of the worst. And yet he, like with almost everything else that Trump has said in 2024, and before that, I might add, that was a lie. Instead, his regime has indiscriminately gone after all immigrants, not just those who are undocumented, but legal immigrants and people who have done everything the right way. So a lot of people just get swept into this desire to, on the part of mainly Stephen Miller, apparently, to get rid of immigrants in our country. So the president has insisted that travel bans and visa processing suspensions affecting immigrants from 92 countries. He's made it really tough for people from those countries to even get here. He has targeted international students with student visas declining from 91,000 to 42,000 from 2024 to 2025. So you can imagine the impact this is having on our educational institutions, many of whom welcome students from abroad to add to the diversity, not to mention the payment of tuitions. And he has also tried to override the Constitution by redefining or basically getting rid of birthright citizenship through executive order. That this is a case before the Supreme Court. Denaturalization is just the latest step in this regime wreaking havoc on our already broken immigration system, trying to break it beyond repair from where I sit. And he is now telling 24 million naturalized Americans that their citizenship can be questioned. And I think when I say this hearing is bizarre, I mean, you're going to use conduct that occurs 10 years after the naturalization was conducted or the application for naturalization was submitted, and conduct 10 years later to somehow go back to the point of the application to determine whether there was fraud committed. That's very bizarre. So 24 million already naturalized citizens. And I happen to be the only naturalized citizen sitting on this committee. And I am horrified by the implication that naturalized citizens basically get second-class citizenship. Not only, and should they commit crimes, yes, as citizens, they should be prosecuted like any other U.S. citizen. But what the laws or bills like the Scam Act does is to subject the naturalized citizen to even more harm or more than what would be visited upon a U.S. citizen, which a naturalized citizen, by definition, is. So let's be clear. This has never been about law and order for the Republicans. This is all about getting immigrants. It's about terrorizing immigrant communities, whether it be ICE officers who are acting outside of what one would consider reasonable behavior, and using our immigration system as a pretext, basically to keep certain people out of our country. As a naturalized citizen, I'm proud of it. I can't think of a more undemocratic, un-American thing to do to someone who chooses to become a U.S. citizen, to hold this over their heads and treat us like second-class citizens. I do have some questions, but I still have some time. I have a question for Professor, excuse me, there's one professor sitting there in the middle. Okay, Professor Spiro. So what do you think about this effort? Like efforts like the act that I just talked about. You mentioned it. What do you think about this effort to try and impose even more requirements on naturalized citizens than we do on citizens?
So I agree, Senator Harino, that this is of a piece with the war on immigration, including the war on legal immigration. Mm-hmm. And it does send a message that citizens who have naturalized are not secure in their status. So Senator Schmidt earlier said that fraudsters should be scared, terrorists should be scared, spies should be scared. Naturalized citizens should not be scared. They should not be afraid. But I think this is also largely a sideshow because there are very few naturalized citizens who are actually going to be denaturalized under either existing authorities or under the proposed legislation, because the courts are so vigilant with respect to denaturalization cases. And to take post-naturalization conduct and refer it back to the date of naturalization is really a kind of perilous inquiry. Again, I think we can all agree, as Senator Welch started us, that if you were a member of a terrorist group at the time of naturalization, then you should not be naturalized. But if 10 years later you do something.
So we can talk about people 10 years later who commit murder, heinous acts, but the Scam Act also allows people to be prosecuted for welfare fraud. Just about anybody who is in the welfare program can be accused of welfare fraud. See, this really opens up the way that people can be sought to be denaturalized, and there is some kind of a directive that our agencies, citizenship and naturalization agencies, are supposed to come up with 100 to 200 cases of denaturalization every month. They're not talking about going after terrorists. 100 to 200 every month. No, they're talking about going after the people that they could accuse of a whole bunch of other things. And that is why 24 million people who are naturalized in our country are going to be subjected to this kind of so-called oversight, and I think is, to say the least, it's more than astounding. It should be unconstitutional. Thank you.
Thank you. Speaking of astounding, your comments are astounding, Senator. You mentioned a few words, horrific. I think to the American taxpayer that's been ripped off by people who came to this country, to rip them off, that's horrific. You talk about bizarre. No, it's my time now. It's my time. You went over time. It's my time. Bizarre is the idea that you would be here in this committee defending violent murderers from being deported, that you would be defending violent rapists from being deported, that you would defend people who took advantage of the good people of this country, their taxpayer dollars. That is bizarre. A terrorist who kills American citizens, you know what's bizarre is your defense of that. So forgive me if your 24 million Americans should be, or naturalized citizens should be afraid. That's ridiculous. You have no. You have nothing but fear mongering here. What I'm saying in this bill is, if you do those things to the American people, if you take advantage of taxpayers, you're not recognized. If you commit a terrorist act, if you commit wholesale welfare fraud, within 10 years, you're damn right we're deporting you. If you're convicted, it's not being accused of anything. If you are convicted in a court of law of these crimes, absolutely we should not only convict you, but we should deport you. Gone. And if you think that's some sort of like negative assertion towards me, I'll take it. I love it. That's what we should be doing more of in this country, because people are coming here and they're ripping off taxpayers. And I, for one, don't want to see it anymore. And if you want to have that debate in public, we can do it. But that's what this hearing is about, to examine the Scam Act. So I'd just like to expose a few of your lies in your most recent dissertation on the dais here. So, Mr. Cuccinelli, I want to ask you, federal naturalization law requires prospective citizens to show good moral character, attachment to the Constitution, and a disposition towards the good order and happiness of the United States, correct?
That is correct.
Okay. So a naturalized citizen who later joins ISIS, spies for our enemies, joins a cartel, or steals millions from American taxpayers through fraud, raises the simple question of whether that person actually met the requirements for citizenship, right?
It does, yes.
And really, on many of these instances, you're building on the 5 years to 10 years, right? I mean, within 5 years.
That's right. That's the biggest difference.
That's the biggest difference.
Plus
here.
Adding the fraud pieces.
So I want to use, with the time that I have, let's make this a little bit more concrete. And you referenced this individual. I want to start by addressing the case of Mirsad Ramich. Mirsad Ramich was approved for naturalization in 2009. But refused the oath, refused to cite the oath of allegiance at his naturalization ceremony, and instead recited the Islamic oath and Islamic oath and cursed all non-Muslims. Is that correct?
Yes.
Okay. Do you think that Mr. Ramich at that point was attached to the principles of the Constitution and well disposed to the good order and happiness of the United States?
Quite the opposite.
Okay. But he was allowed to be naturalized anyway, correct?
He was.
Okay.
A factory line fashion, undoubtedly.
Yes. So Ramich later joins ISIS and participates in atrocities that killed more than 100,000 people. Is that correct?
He did participate in ISIS battles, yes.
Okay. Do you think that Mr. Ramich joining ISIS and engaging in terrorism within a few years of becoming a citizen is evidence that he was not attached to the principles of the Constitution at the time of his naturalization?
It certainly is, yes.
Okay. So I want to talk about the terrorists at Old Dominion. This man was born in Sierra Leone and became a naturalized citizen. He was then convicted of attempting to carry out an attack on behalf of ISIS, but he was released from prison back onto the streets of the United States rather than denaturalized and deported, correct?
That's right.
Okay. And the consequence of the U.S. legal system allowing him to roam free in our country rather than denaturalizing him and deporting him was that he was able to commit a terrorist attack involving an ROTC program in Virginia, killing a lieutenant colonel. Is that correct?
Yes,
Yeah.
he did.
This is just the absurdity. I actually think this is sort of a common sense solution here, but that's where we are. Mr. Fishman, I want to ask you, under current law, joining a terrorist organization is grounds for denaturalization, but only if that occurs within 5 years, correct? 5 years of the naturalization?
Yes, and it's also a rebuttable presumption. The naturalized citizen is free to present evidence that no, in fact, he did support the Constitution in the trial.
So, but in this instance, Jallow joining ISIS occurred more than 5 years after his naturalization. So denaturalization, current law wouldn't cover him, correct?
Under current law.
Correct. And even if he had been denaturalized, the Supreme Court has interpreted the immigration statutes to not permit that conduct as deportable offense, correct?
Yes.
Okay. But that was a statutory holding by the court, so Congress, and this is the point, Congress is free to change that, correct?
Well, the courts indicated Congress is free to lower the government's burden of proof in these cases. The question of how long post-naturalization an act can occur and still relate back, that will be the Supreme Court telling us.
Correct. And that's why I think it's important to note that the SCAM Act includes a provision that abrogates that erroneous holding. It would ensure that terrorists like Jallow are denaturalized and deported. I want to now recognize.
Could I comment, Senator?
Sure. Yeah, absolutely.
Mr. Fishman noted correctly the rebuttable presumption. I think post-naturalization, anything you do will be subject to a rebuttable presumption based on the Supreme Court's history of rulings in this area. I do not think you'll ever have the constitutional authority like you do on the front end of naturalization. Congress has near plenary power to not give an individual the opportunity to rebut the presumption raised within the law, just based on the existing, long time, really, Supreme Court precedent.
Yep. Senator Welch.
Thank you very much. Professor Spiro, a lot of the examples that the chairman gave are pretty appalling crimes. And is there any reservation or inability of the prosecutor to take that person to justice and put them away in jail for as long as the judge determines?
Not at all, Senator. I mean, people who engage in heinous crimes or terrorist activity should be subject to the full force of the criminal law.
Right.
But they should not be subject to an additional penalty that relates to sacrificing their citizenship.
Thank you. And just on this question of denaturalization, I think maybe when I was out, somebody talked about it, but it's actually been very rarely used in either Republican or Democratic administrations. Can you just elaborate on that?
Well, that's because the courts are so searching in their scrutiny of denaturalization cases, so that the bar is a very high one. You really have to show that there was a fraud at the time of naturalization itself. And so there aren't that many cases in which that standard can be satisfied. The case that Senator Schmidt alluded to with respect to the person who refused to take the oath, that seems like an obvious case where denaturalization would be appropriate.
In the Schneiderman case, the court warned against construing congressional statutes governing denaturalizations as potentially circumscribing liberty of political thought, which is essentially the free speech right that any citizen has. Is that correct? Am I right in that?
That's correct, Senator. So Schneiderman involved the attempted denaturalization of a member of the Communist Party. And in that case, the Supreme Court undertook a really searching examination of whether membership in the Communist Party is consistent with attachment to constitutional principles, and it rejected the government's attempt in that case. So First Amendment principles are clearly at stake here when it is associative activity that the government is attempting to use by way of showing illegal procurement.
Right. So it's been the history of the court to protect free speech rights and rights of association. And those involve people who have the right to associate that I may profoundly disagree with and think what their point of view is actually detrimental to the well-being of this country, right?
Absolutely. So in Schneiderman, Justice Rutledge had a very powerful concurrence in which he argued that, quote, no citizen with such a threat hanging over his head could be free. You know, that his best course would be silence or hypocrisy if he were to face the possibility of denaturalization for First Amendment activities. And in Rutledge's opinion, this is not citizenship.
Right.
Yeah.
So I just want to summarize to see if I have this right. If a person lies, and that can also be a lie by omission, that they're part of a terrorist group, let's say, they can be denaturalized under current law.
Yes.
And if a person commits a crime subsequent to becoming a naturalized citizen, they are subject to the full force of the law, just as you and I are. Is that correct?
Yes, Senator.
And the number of cases that have been prosecuted for denaturalization historically under Republican and Democratic administrations has been really quite small, correct?
Exceedingly small.
All right. Well, that's my concern, Mr. Chairman, because I do think there's a lot of other activities that are going on in this whole immigration debate that we've had in this country where we need more attention. And I'm talking about those high school kids, and you'd probably share my appreciation, for them. But where I have this confidence that under existing law, the person who commits fraud, and that includes by omission, not affirmatively acknowledging their terrorist sympathies, they can be denaturalized. And then once that person becomes a citizen, they're subject to the full force of the law, and that includes going to jail forever. Is that right?
Yes, Senator.
Okay, thank you. I yield back.
Thank you, Senator Blackburn.
Thank you so much. And I want to thank you all for being here. And of course, the SCAM Act is something that we're bringing forward. I also have the Fraud Accountability Act. And these are things that Tennesseans are talking about to me. They are absolutely appalled with what is being uncovered by Vice President Vance's task force and the amount of fraud that people who are here in the country, legally or illegally, or have been naturalized, are choosing to commit against U.S. citizens and the American taxpayer. And the Fraud Accountability Act, which several of us have done, would actually go in and amend the Immigration and Nationality Act and make any act of fraud, whether it's by against an individual, a U.S. citizen, or against a local, state, or federal government, a denaturalizing and deportable offense. It also would put in place that these cases could be heard by any federal court instead of having to wait for an immigration court. But Mr. Cuccinelli, I want to come to you on this. And with all the discussion that we have had here today, and with the fact that we do have some members on the other side of the dais that think that sanctuary cities are just fine, and that breaking the law is just fine when it applies to immigration, I want you to talk for a minute about the role that Congress has to play in strengthening these laws, doing things like the Scam Act or the Fraud Accountability Act, and standing up against these sanctuary cities.
So when you talk about fraud outside the government context, you're really leaning on a naturalization or denaturalization discussion on the law Congress has already established about people committing to the good order and the well-being of the United States and the people of the United States. And I would note, we're talking about ways to accomplish denaturalization. I would suggest, I walked through numbers that are in the tens of thousands in my opening statement, and I would suggest that there's another simpler reason that there aren't more denaturalization proceedings. It's that they're hard. And that because the government has put to its proof one single case at a time. What you alluded to the vice president uncovering is system-wide fraud. I was an attorney general. I shattered records for healthcare fraud recoveries. And there are actually simple, systematic ways to reduce fraud. There are simpler, systematic ways to keep people from being naturalized in the first place, where Congress has far more process power under the Constitution than after naturalization, but it requires the will to do so. And, we talked about the Ramick case. I mean, frankly, every USCIS person in the room should have been jumping up to make sure that person's citizenship papers weren't signed. Because they were violating U.S. law then. He was. And but there's this, and this isn't partisan at all, there's this factory line mentality that, in fact, the burden of proof is on the government to deny people. And that is not what the law says. The law says the burden is on the prospective immigrant to prove they have good moral character, to prove they are well disposed to the constitutional principles of the United States, to prove that they will participate and contribute to the well-being and good order of the United States. We do not hold them to that proof. The presumption, including in this building, is that the government has to give a reason not to grant the benefit. The burden of proof as a practical matter has been flipped. And I don't know how far back that happened. It was long before I was ever crossing the Potomac. And, I'm from Virginia. I think God put the Potomac there for a reason. I try to respect it, stay on my side. But it's good to be with you all today. And I think you're on the right path. On the after the fact version, I would also suggest that there are plenty of ways, especially when you get into the terrorism area and you get into folks who are predisposed not to the well-being of the United States, that they can be screened out without the kind of restrictions, legal restrictions, appropriate by the way, that you would use in, say, hiring an American who is already an American. Those kinds of things can be applied, and they should be, but they're not. That's not happening right now.
Thank you. Thank you, Mr. Chairman.
Mr. Chairman, I'd ask for unanimous consent to introduce a report from the Brennan Center outlining the Supreme Court's jurisprudence guaranteeing strong protections for naturalized citizens.
Without objection. I'd also, in the long tradition of denaturalization, like to enter into the record a recently produced Congressional Research Service report discussing our nation's tradition of denaturalization. From the report, President Teddy Roosevelt called on Congress to revise the existing naturalization laws, including to formalizing denaturalization proceedings following reports of widespread abuse. The first denaturalization law was included in the Naturalization Act of 1906 and delegated to U.S. attorneys the authority, quote, upon affidavit showing good cause, therefore, to institute proceedings for the purpose of setting aside and canceling the certificate of citizenship on the grounds of fraud or illegal procurement, end quote. They'll be entered into the record without objection. Senator Cruz is coming, should be here in like 2 minutes. So in the 2 minutes that I have to filibuster here, I'm going to ask you, Mr. Cuccinelli, you talked about, you know, that incident when the individual refuses to take the oath and cusses out people. In your experience, what changes to the naturalization process would you recommend that we currently have, you know, changes to the system that we have now?
So part of the problem that exists now is the corporate culture that has grown up around this process, which is in USCIS. If you go back to the Clinton era, it was INS, and nobody in particular is to blame for that. But the pressure is always to move people through, whereas the pressure ought to be to vet thoroughly for those who, frankly, will contribute to the United States of America more rather than either less or maybe detract from fraudsters, terrorists, et cetera. And you know, I'll be really blunt on some examples. Two religious groups come to mind: Hindu nationalists, which we're seeing play out in India, and then Islamists who are committed to Sharia law. Sharia law is a governmental system that accompanies Islam. It is not a religion of itself. It's a political structural belief. And if you look at Pew data, no right-wing organization, Mr. Chairman, and I'll pick the worst, I'll go to the biggest number. Afghanistan has a 99% commitment, meaning of the surveyed population, to Sharia. Well, Sharia is a governmental system incompatible with the constitutional principles of the United States. So is Hindu nationalism. And if people are identified as holding those views, they should be immediately excluded from the opportunity to immigrate to the United States. And there's no effort to vet those positions in any meaningful way, case by case, from rather obvious countries. If you want to be efficient about it, you could apply all the same, you know, questions to every country if you wanted to treat everybody the same as a matter and give up the efficiency that involves. But I mean, that's an enormous number that fits perfectly legally within the constitutional structure on the front side of naturalization, not so much on the back side of naturalization.
Thank you. Senator Cruz.
Thank you, Mr. Chairman, and I appreciate your holding the hearing open to give me time to get here. Thank you. Mr. Cuccinelli, good to see you.
Always a pleasure.
Let's start with this. Citizenship through naturalization is not automatic. Is that right?
Absolutely not.
In fact, 8 U.S.C. Section 1427 lays out specific requirements before becoming a naturalized citizen. Is that right?
Absolutely. And they are ancient from this country's standpoints.
Most importantly, every applicant must, 1, be a person of good moral character, 2, attach to the principles of the Constitution of the United States, and 3, well disposed to the good order and happiness of the United States. Is that correct?
Yes, it is.
If an applicant fails to satisfy any one of these requirements, the government must deny the application. Is that right?
That is what the law says.
And that process includes reviewing criminal history and background, correct?
That is the process. It is not always followed.
And it also includes a naturalization interview, a citizenship test, and an oath of allegiance. Is that right?
Yes, that's right.
But under both the Obama and Biden administration, the government stopped properly vetting applicants for naturalization. Do you agree with that?
Vetting is, yes, I do agree with that, and it's continues to be a growing problem just in the raw number in the case pipeline.
Is it also correct that during the Obama administration, it was discovered that the government had failed to upload the fingerprints of at least 148,000 immigrants, many from countries with ties to terrorism?
Yes, that's correct.
And as a result, at least 858 individuals who were ordered removed under one identity were instead granted U.S. citizenship under another identity. Is that right?
Yes, it is.
And after more than 12 million illegal aliens have crossed in our border illegally under the Biden administration, would you agree that the problem has only gotten worse?
Absolutely. That's my reference to the very loaded pipeline. Yes.
And tragically, this is not a hypothetical. Just 3 months ago, in Austin, Texas, a naturalized citizen from Senegal murdered 3 and injured 15. Mr. Fishman, the Austin shooter entered the United States on a tourist visa, not an immigrant visa. Is that right?
I believe so, yes.
And the Austin shooter committed multiple crimes and was arrested multiple times before he received a green card and before he was naturalized. Is that right?
Yes.
But the Obama administration made him a citizen nonetheless, despite his crimes, despite his arrests.
Yes.
3 people were murdered, 15 more were injured, and the shooter was found wearing a sweatshirt emblazoned with "Property of Allah." The Obama administration's failure to vet naturalization applicants cost Americans their lives. Those failures ripple forward in time. Obama's errors are surfacing today. Biden's errors, tragically, predictably, will surface tomorrow. That's why denaturalization cases are not token, they're urgent. Mr. Cuccinelli, is it correct that we still don't know the number of people like the Austin shooter who were wrongfully naturalized despite documented criminal records?
Oh, absolutely. And we will never know it.
And
it's already slipped through our fingers.
Unfortunately, it gets worse. Let's turn to the requirement that applicants must support the Constitution and embrace our country's basic values. Mr. Fishman, during the Biden administration, would you agree that the civics test was so easy that it failed to screen applicants?
To any appropriate degree, yes.
Among 100 publicly available questions, applicants were asked only 10 questions and only needed 6 correct to pass. Is that right?
Yes.
That's 60% score to become a U.S. citizen. Anywhere else, 60% is a failing grade. That is an F, except under Joe Biden if you want to become an American citizen. And whereas in the past, answers needed to be given verbally in English, the Biden administration went a step further and gave multiple choice questions on an electronic tablet. Is that right?
Yes.
You didn't even need to speak English in order to pass the test. A process this deliberately lenient doesn't screen for citizens. It is a rubber stamp to get voters that I believe Joe Biden wanted to vote Democrat.
Well, of course, and that goes back to the Clinton administration, where there was a concerted effort to get as many people naturalized as possible because they were promised by advocacy groups they'd all vote in the 96 election for the president and vice president.
Even the oath of allegiance was effectively abandoned. Mr. Fishman, are you familiar with Mirsad Ramik?
I've unfortunately learned much about him today.
At his naturalization ceremony, Mirsad Ramik refused to recite the oath of allegiance to the United States. Is that right?
That is what I've heard, yes.
And instead, Ramik recited an Islamic oath and cursed non-believers. Is that right?
That is what has been testified to today, yes.
And yet the Obama administration gave him citizenship nonetheless.
That is apparently, yes, the case.
And 1 year later, he became an ISIS fighter in the Middle East. Is that right?
That is what I've learned today, yes.
look, a basic question anyone should ask, what in the hell are they doing?
I think there should be an investigation of those who were there when he did that. That was clearly, even under current law, entirely inappropriate and unlawful.
Mr. Cuccinelli, a joint DOJ and DHS report in 2018 found that at least 148 individuals convicted of terrorism had become naturalized U.S. citizens. Is that right?
Yeah, that's my recollection.
148 people who passed the test, who were deemed to have satisfied the oath, who were handed the certificate. The naturalization process did not catch up to them. It gave them the veneer of citizenship. And we only know these names because the Trump administration officials went looking. 148 is the floor, not the ceiling. The tip of the iceberg. The pattern is consistent. Among recent denaturalization cases brought by the Trump DOJ, one individual concealed child sexual abuse offenses. Another swore allegiance to Al-Qaeda. Yet another joined Al-Shabaab. And one even secretly served as a Cuban intelligence agent. Professor Spiro, do you believe we should be granting citizenship to individuals convicted of child sexual abuses?
Of course not if the offense predated naturalization. One thing I will say is you've got 4 examples here, and the number of individuals who are naturalized is about 800,000 a year.
Okay.
So that's, whenever you take a population of 800,000 individuals, you're going to get a couple of bad apples.
All right, let's talk about those bad apples. Do you believe we should be granting citizenship to someone who swears allegiance to Al-Qaeda?
Of course not if they did so before they were naturalized.
All right, let's take Mr. Romick. Do you believe that the Biden administration was right to grant citizenship? Actually, the Obama administration. I don't want to misstate it. Do you believe the Obama administration was right to grant citizenship when Mr. Romick refused to cite the oath of allegiance and instead recited an Islamic oath and cursed non-believers? Was that decision right?
No, because he failed to satisfy the requirements for naturalization at the time of naturalization.
Mr. Cuccinelli, none of these individuals were entitled to American citizenship, were they?
No.
Every American in this room, if you're an American, has a claim to citizenship, whether through their parents' sacrifice or through their own solemn oath to uphold our Constitution and way of life. Denaturalization does not undo real citizenship. It exposes fraud, it fixes the record, and it corrects citizenship that was never lawfully granted. With that, I want to thank each of the 3 witnesses for being here today. Written questions for the record can be submitted until Wednesday, June 10th, 2026 at 5 p.m. And we will ask the witnesses to submit their responses within 2 weeks so that by Wednesday, June 24th, 2026 at 5 p.m. Thank you again to all the witnesses, and this hearing is adjourned.